Distinguished delegates, participants, and partakers. Greetings to one and all. It is a glorious moment to extend my warm wishes on behalf of Sree Ayyappa College for Women and gives me tremendous contentment to be presenting the welcome address among the most esteemed personalities who have won accolades in their respective fields. With immense pleasure, let me accord a special welcome to our beloved principal, Dr. K.V. Jayashree, who with her humble and affectionate nature is motivating us all towards the path of academic excellence and quality enhancement. On behalf of everyone assembled here, I welcome you, madam.
Thank you. Thank you.
I feel extremely happy to extend a warm welcome to Dr. A.M. Sridharan, Director, UGC HRDC Kannur, University Kannur. He has readily accepted our request to be part of this joint venture for organizing this wonderful program. Welcome you, sir. It is an opportune moment to refurbish about the human rights in the pandemic era with our esteemed speaker of the day. With due respect, I welcome Dr. Girish Keshava Pillai, Principal, Havans N.A. Palkiwala Academy for Advanced Legal Studies and Research, Kozhikode, who is going to provide us with an overview of human rights in a pandemic era. Welcome you, sir.
Thank you, madam.
Thank you, sir. The organizing secretaries, Dr. R. Janada Kumari, Dr. M. Meera, and Dr. T. Anida have been working very hard for shaping this program in its present form. I extend a cordial welcome to you all. I also welcome Dr. Radha, who is moderating today's session, and all our IIC members. I extend my hearty welcome to faculty members from our college and faculty members from other esteemed institutions. I ensure this session will be profitable and fruitful to everyone present here. To all of you, once again, thank you for being here. Welcome and enjoy the session. Thank you.
Thank you, Sriya, for your warm words of
Dr.
welcome.
Radha.
Human rights are needed to navigate the pandemic crisis in such a way that it will allow us to focus again on achieving sustainable development and peace. Here's an apt resource person who is an expertise in law to enlighten us. And now it's my prime duty to invite our resource person of today's session, Dr. Girish Keshava, Principal, Bhavan N.A. Palkiwala Academy for Advanced Legal Studies and Research, Kozhikode. He is an eminent and vibrant personality who has started his professional career as assistant professor in Dayanand College of Law, Latur, Maharashtra. Later, he has served in various capacities as vice principal and principal in the same college till 2020. He has a number of publications to his credit related to human rights. Adding to his credit, he has edited and co-edited a number of books, and he has practiced and advocate from 1992 to 1998. He has attended a number of seminars and conferences and had been a resource person and even has chaired many sessions. He was also a former member of the Board of Studies, Commercial and Mercantile Law, Rajarshi Sahu College, Latur, Maharashtra, and had membership in various academic bodies and committees related to law. No doubt, he is an apt resource person for today's session on human rights in the pandemic era. Over to you, sir. The virtual stage is all yours.
Thank you, madam. Good evening, all friends. This session, I would like to be more interactive than a monotonous lecture method. I selected this topic in the wake of the new pandemic, COVID-19. But when you look at the pandemic COVID-19 and the various pandemics and the human rights, I found a relation. Both are the creation of human beings. The pandemics which are coming from the history, if you are analyzing, you will see that the emergence of these infectious diseases started from the first agrarian revolution or it is otherwise known as the Neolithic Revolution. It started when the human hunters, gatherers settled into villages and domesticated the animals for their personal purpose and for having the organized harvesting. The first step of manipulation of nature, which happened in this way, created a situation where the diseases which were concentrated on the animals transmitted to the human beings, and the new forms of pandemics started developing. The examples of smallpox, malaria, measles, plague, etc. are the glaring examples of the animal-driven pandemics. Then in the next stage, there are certain human practices which caused the development of a pandemic. One who is reading the articles written by Moran and Fauci, you will find that they have listed certain diseases which are the creation of human activities. The water storage practice in Northern Africa about 5,000 years ago led to the emergence of the mosquito Aedes aegypti, which created the emergence of yellow fever, dengue, chikungunya, Zika, etc. The depots which are used for rubber tires created the breeding ground for the mosquitoes like Aedes albopictus, which spread some viral diseases globally. Then deforestation is connected with the Zika and the Hendra viruses. Road building and environmental degradation is found responsible for the pandemics like Bolivian hemorrhagic fever and HIV. Then the cholera and tuberculosis are the creation of poverty, crowding, and poor sanitation. So by analyzing the sequence of these diseases from its emergence, David M. Morans and Anthony S. Fauci, who is the director of the National Institute of Allergy and Infectious Diseases in America, he opines that this recent experience that we have entered a pandemic era. So he concludes that this shows that we have entered a pandemic era. That's why I selected the word pandemic era in my title. So you will see a lot of new pandemics are arising throughout the world. The recent example being the COVID. And even before COVID, we have experienced the onslaught of Nipah. There was the onslaught of Ebola virus. So all these we can trace back to the manipulations which the human beings carried on the nature. And now the COVID-19 pandemic became more prominent because of its spreading power. Most of the other pandemics were not that much infectious, whereas the COVID-19 became a global pandemic because of its nature of spread. And all these pandemics created certain kind of human right problems. However, the problems which were created by the pandemics in the previous editions were limited in nature. Whereas the COVID-19 is having more human right consequences. And by that way, we can assume that the COVID-19 or the other pandemics which are created by the human being by manipulation of the nature. That is where the opening comments of the moderator becomes important. Sustainable development. We have exploited the nature in such a manner that it is very difficult for the coming generations to survive. The emergence of pandemic is an example of that. And it has pushed us to a corner. The humanity has been pushed to a corner from where we are struggling for an escape. So in that way, I can say that the protection of environment is the first human right, which is to be achieved or which is to be realized. The sustainable development under the environmental protection law say that we have to use the environment in such a manner that it is available to the future generation also. If we are following the principle of sustainable development, then the incidence of such pandemic can be significantly reduced. So let us keep our first target of human right as protection of environment and the sustainable development. You cannot ignore the development for the purpose of environment. We cannot ignore the environment for the purpose of development. What we have to do is a balancing of environment and the development of economy. So there, the concept of sustainable development becomes more important. Now, the right to environment is part of Article 21 of the Constitution. And the Article 21 of the Constitution has been interpreted proactively by the Supreme Court. Now it has become a bundle of rights. The rights which are not articulated in the Constitution or any other documents are now being read into Article 21 by the activist approach of the Supreme Court of India. So therefore, let us hope that the right to environment as a human right get more priority because of the emergence of the pandemics like COVID. And you may know what is human right because it's a program on human rights. And the last few sessions, you might have been amply enlightened about the human rights and the nature of human rights and the importance of human rights. In the beginning, I was remarking that the pandemic and human rights are the creation of human beings. My first point was the destruction of environment as a reason for emergence of a pandemic. Human rights. When we are looking at the human right also is the result of dissociation of human being from the society. If you are going through the history before the 14th and 15th century, the most of the documents which are available for us speak about duties. You have a duty. Even in the Indian philosophy, you will see that there is no articulation of rights. There are duties. Does it mean that there are no rights? No. It was not the denial of rights, but the right in the present form was not recognized. The society was viewing everything in the societal perspective. So the vision during that time was, when you are fulfilling your duties, the rights are fulfilled. Even in the modern legal thinking, you will see that a right is defined as having a corresponding duty. So therefore, these are two different concepts. Right is a thing which you can enforce, whereas duty is a thing which you have to compel. So the difference was that during that time you were not able to enforce your rights. You are not having an opportunity to enforce if it is violated. It was taken care of by the society, or it was taken care of by the state by enforcing the duties. Whereas the concept of right developed in Europe during the time of Renaissance. The Renaissance was boosted by the philosophy of Alberti, an architect. He said that man can do anything if he wills. So before that, we were under the control of religion, and everything was attributed to the God. So there was a supremacy of religion during the time before the 15th and the 16th century. Whereas the statement of Alberti gave a new impetus for the humanity. So from there you will see the revolt against the existing systems started, which created the Protestant religions, the emergence of Protestant religions, and man began to believe himself that he can do. When man started believing in his own abilities, then naturally he started to think that even without the help of a society, I can survive. So this has created a kind of individualism, and that kind of individual development of individualism crystallized into the enforceable claims and enforceable interest of the people, and came to be termed as the rights. And the human rights probably started developing from that period. That's why I told that it's a result of the deviation of individual from the society. It's a man-made concept. And the pandemic, as we have seen, it's also created by the human beings by exploiting the nature. And both are, in one way, is the result of the individualistic thinking of the human being. Now, when we come to the human rights aspect of the pandemic, certainly it creates a lot of challenges. I would like to understand the human right in a pandemic era in two ways. One way is the impact of pandemic on the realization of human rights. And the other is the impact of countermeasures adopted by the state on human rights. So the pandemic itself is having certain impact on the human rights. And when the state is acting for preventing this pandemic, that state measures may also violate human rights, or we have to test those actions in the light of human rights. When I am discussing about the human rights, I'm discussing it in a global perspective, because the global human rights are wider than the human rights which are available in India. In India, you may know, under the Protection of Human Rights Act, human right in India means the human rights which are enforceable in India. The human rights which are not enforceable in India are not considered as human rights under the Protection of Human Rights Act. But it does not mean that the human rights are having limitation in India. By the interpretation of the Constitution, the Supreme Court of India has adopted many of the rights as inarticulated rights under the Constitution. If you are looking at the interpretation of the Supreme Court regarding Article 21, the right to life and personal liberty, you will see that a large number of cases are put under Article 21 of the Constitution. Wherever the Supreme Court found that one of your basic rights is violated, and there is no explicit mention of that right under the Constitution, the Supreme Court read that right into Article 21 of the Constitution so that to make it justiciable. So when we are discussing about the impact of pandemic, on the realization of human rights, the first right which comes to my mind is the right to life and personal liberty. In India, no discussion of the human right can be done without discussing the right to life and personal liberty. Article 21 of the Constitution says that no person shall be deprived of his right to life or personal liberty except according to the procedure established by law. This article of the Constitution has been incorporated in the Constitution, getting inspiration from the Universal Declaration of Human Rights, Article 3. And subsequently, you will see that in the international sphere, the right to life has been more particularly articulated in Article 6 of the International Covenant on the Civil and Political Right. But when we are looking at the right to life, what is this right to life? Is it a right to live? Or is it something more than that? The Supreme Court interpreted that the right to life is not mere animal existence. The right to life means a right to life with human dignity. So you know that when we say that a right to life with human dignity, it encompasses a bundle of rights. Whatever be the things which are necessary for you to live with dignity, it comes under Article 21 of the Constitution. It's capable of interpreting to such an extent that all your basic needs can be brought under the purview of the right to life. And the right to life, right to live with dignity invariably encompasses the right to health. The right to health was not included under the fundamental right part of the Constitution. The people who have studied the human rights, they may know that there are two types of human rights, mainly. One part is the civil and political right, and other is the economic, social, and cultural rights. The Universal Declaration of Human Rights, the first part contains the civil and political right, and the second part contains the economic, social, and cultural right. There is a difference between these two rights. What is the difference between these two rights? The first part, the civil and political rights are justiciable rights. They are the rights which are to be guaranteed by the states immediately. Whereas the part 2 contains economic, social, and cultural rights which are not made justiciable immediately. I was using the word very carefully, not justiciable immediately. Does not mean that they are not important. For the realization of the civil and political rights, the realization of economic, social, and cultural right is essential. But If you are looking at the nature of these two rights, you will see that the first category of rights are essential, which are basic. At the same time, the states are having no difficulty in implementing them because no positive effort from the state is necessary for the implementation. For example, the right to equality, the freedoms, freedom of speech and expression, freedom of assembly, freedom of movement, freedom of trade and profession. You look at the nature of these rights, a right to life, right to liberty, the rights of the prisoners, the right of an accused person. When you look at these rights, you will see that these rights can be implemented by the state and a simple declaration is sufficient. Whereas when you come to the economic, social and cultural right, the economic, social and cultural right requires a kind of positive action from the state. The realization of that right depends on the capacity of the state. That is why the economic, social and cultural rights are to be made justiciable as and when the state is capable of providing it. Or in the International Covenant on Economic, Social and Cultural Right, you will see that the rights are to be progressively realized. The concept of progressive realization is provided in the International Covenant on Economic, Social and Cultural Right. So Constitution also is having two types of rights. Some rights are kept as the fundamental rights, which are justiciable. And if the fundamental rights are violated, you can approach the Supreme Court or the High Court, and the Supreme Court or the High Court can give you a remedy. Whereas many of the economic, social and cultural rights are put in the directive principles of state policy. And the directive principles of state policy, you know, there is a common understanding that they are not justiciable rights. But they are not unimportant. They are also important. But it is kept as an objective of the state to realize when the state is progressing. So when we look at the right to health, the right to health is not an explicit right under the Constitution, except we can read it into the directive principle of state policy. The Universal Declaration of Human Rights, as well as the International Covenant on Economic, Social and Cultural Right, defines the right to health as the right to attain the highest standard of physical and mental health for everyone. So everyone is having a right to the enjoyment of highest standard of physical and mental health. And it is the duty of the state to take measures for the prevention, treatment and control of epidemics, endemic, occupational and other diseases. And it should create conditions which assure all medical services and medical attention in the event of sickness. So it is a duty of the state to provide medical service and medical attention if a person is sick under Article 12 of the International Covenant on Economic, Social and Cultural Rights. The United Nations Committee on Economic, Social and Cultural Rights elaborated this right, and they said that the right to health is not an independent right. The right to health is closely related to and depend on the realization of other human rights. So the right to health means you should attain such a stage of health, mental and physical health, where you are capable of enjoying all the rights which are enumerated under the international covenants. It includes right to food, housing, work, education, human dignity, life, non-discrimination, equality, the prohibition against torture, privacy, access to information, and the freedom of association, freedom of assembly, freedom of movement. And this should be available in sufficient quantity. And it should be accessible to everyone without any discrimination, irrespective of any other consideration, caste, creed, religion, nationality, or anything. It should be accessible to all. And it should be affordable. The people should be having the capacity, or should be given in an affordable way. Even the marginalized group should be provided with this right to health. And again, it is saying that it must be acceptable. Acceptable means it must be respectful to the medical and cultural ethics, and scientific. It must be scientifically and medically appropriate. It must be of good quality. That's the problem in the realization of the right to health. So right to health must be having a content which is acceptable to all, irrespective of their denominations or ethnicity, nationality, etc. But only the problem is that these rights are enumerated as progressive rights depending on the capacity of the state. That creates the problem. As we all know, there is a wide disparity in the economic power of the state. This disparity in the economic power of the state creates disparity in the health care services. The states which are having relatively better economic system will have a more efficient healthcare system, whereas the countries which are having comparatively poor economy will have inadequate health care facilities. This disparity is a reality in realization of the right to health. This is the situation which is existing throughout the world generally. And the emergence of the pandemic complicated the matter again. As we all know, the reports suggest that we are in the verge of a recession, a pandemic-driven recession. The poor countries will be more affected comparing to the developed countries. So therefore, it will have an impact on the realization of the right to health. The right to health we can guarantee. You have a right to health. A declaration of right to health we can guarantee. But this right to health is interpreted as including the right to healthcare services. So when we say that there is a right to healthcare services, some kind of action, positive action from the state becomes necessary, which requires resources. In a situation like the pandemic like COVID-19, most of the economy is in the verge of disruption. So therefore, how far the state will be able to afford the right to health is a question. In India, it is particularly important because though it is not an explicit fundamental right under the constitution, by the interpretations of the Supreme Court in several cases like Rakesh Chandra Narayan, State of Punjab versus Mahinder Singh Chawda, State of Punjab versus Ram Labhaya Bagga, Vincent Panikulangara versus State of Kerala. So in a series of cases, the Supreme Court of India observed that the right to health is part of Article 21 of the Constitution and thereby making it justiciable. In Vincent Panikulangara versus the Union of India, the Supreme Court observed that it is a duty, it is obligation of the state to ensure creation and sustaining of conditions congenial to good health. In State of Punjab versus Ram Labhaya Bagga, the Supreme Court said that it is the responsibility of the state to maintain health services. So, under Article 21, it is the positive obligation of the state to provide the healthcare facilities. That is where the challenge exists. In a situation like this where there is a recession, a pandemic affecting the economy, how far the state will be able to provide the healthcare facilities to all. That's why these assurances becomes futile. Again, the unprecedented increase in the number of patients put an undue burden on the healthcare system. Thereby, there is a possibility that the healthcare system may crumble. All the deserving cases may not get the proper attention because of the paucity of the health infrastructure or the healthcare personnel. It will force the system to make a choice. That is the difficult part. When two patients are coming, where one hospital bed is available, what is to be done? Or if there is a requirement of ventilator and two patients are coming and one ventilator is available, what can be done? This will force the healthcare authorities, the doctor or the health worker, to make a choice as to who is to be given the priority. And what is the basis of that? How will you make that choice is a question. Do we have any guidelines for that? I think no. If there is no guidelines, what will happen? It will lead to undue discrimination. That doctor will decide or the health worker will decide who is to be given that facility. And most often, you will see that the powerful will get and the weaker will be discriminated. This is a huge challenge as far as the human right is concerned. Whether we will be able to provide the healthcare facilities to all in such a situation. We have to find an answer, or we have to make guidelines as to how, in such a situation, the discretion is to be exercised. Sometimes the old aged people may be discriminated. Sometimes the discrimination may be on the basis of your geographical location. A person from one state may be discriminated in another state. It need not go in the international level. For any of these things can happen while exercising this power of choice. So it is one thing which the administrators should address in the light of human rights and the pandemic. And another right which is directly affected by the pandemic is the right to work. Right to work is guaranteed under Article 23 of the Universal Declaration and Article 6 of the International Covenant on Economic, Social and Cultural Rights. And the right to work is also defined in such a manner that the right of everyone to the opportunity to gain his living by work. So the purpose of doing work is to gain his living. So everyone is having a right to do the work for earning his livelihood. If work is not there, there is a denial of livelihood. There is a denial of livelihood means there is denial of food, resulting in a starvation. Then again comes Article 7. Article 7 recognizes the right to enjoy just and favorable conditions of work. Then Article 25 of the Universal Declaration and Article 11 of the International Covenant on Economic, Social and Cultural Rights recognize adequate standard of living. So right to adequate standard of living for himself and his family. And what is this adequate standard of living? It includes adequate food, clothing, housing, and the continuous improvement of living conditions. So the impact of denial of work is having a serious impact on the realization of the human rights. The right to work is important for avoiding starvation. So you have a right to food, you have a right to clothing, you have a right to housing, and you have a right to work for earning your livelihood. This article also recognizes a fundamental right of everyone to be free from hunger. To be free from hunger, you have to earn your livelihood by doing the work. And you know that because of the ongoing pandemic, A lot of people have lost their work. Most of the economies are under the verge of a recession. And the employers are forced to deny the employment. Many are under the compulsion to reduce the wages, compelling the workers to accept a lesser wage. And there is no near hope of recovery from this. And it will invariably result in the starvation and malnutrition. This pandemic has severely affected the production and supply of food materials. It is definitely going to push the large majority into a long grip of starvation and malnutrition. Most of the industries are not in a position to even assure the minimum wages for the workers. This we are discussing about the organized industries. In case of unorganized sector, the problems are more. For example, take the case of a domestic worker, a maid servant who is coming to your house for doing your household work. Many of these people have lost their employment because of the fear of spreading the pandemic. The social security measures for such a unorganized sector is meager, or we can say that it is not existing. Then this is one side of the right to work, which is affected by the pandemic. On the other side, even some of the measures which are taken by the state for ameliorating the ill effect of the pandemic also violate the right of the workers. One of the glaring example is the case of Gujarat Mazdoor Sabha versus state of Gujarat. In July, the government of Gujarat made a circular under Section 5 of the Factories Act. Thereby, a provision is made under the rules that the employer can employ a worker for overtime. The working hours are being increased at the discretion of the employer. And as a normal rule, the wages for the normal work is different, and the wages for the overtime work is different. Whereas this circular provided that for overtime also, the employer has to pay at the rate of the regular working of that employee. And that employee can be put to work for 12 hours continuously as overtime work. This approach of the state has been criticized by the Supreme Court. And the Supreme Court said that unless the threshold of economic hardship is so extreme that it leads to the disruption of public order and threatens the security of India, or of part of its territory, recourse cannot be taken to such emergency powers which are to be used sparingly under the law. I feel this decision will have a far-reaching consequence. This test will be applied, can be applied to the measures which are adopted by the state during the pandemic. The question will be whether these measures are necessary or not, are or whether the present situation is sufficient enough to invoke the emergency powers. And the court said that the financial losses cannot be offset on the very shoulders of laboring worker. So the worker should not be compelled to bear the effect of the financial loss of an industry, according to the Supreme Court, and said that unless there is a grave emergency whereby the security of the state is threatened, we cannot say that there is an internal disturbance which is sufficient to invoke Section 5 of the Factories Act. And therefore, the notification made by the Gujarat government was struck down by the Supreme Court in this case. So therefore, even the measures taken by the state for combating the pandemic violate the human rights of some section of the people. Another group of people who are affected by the pandemic is the aged people. From the beginning, it has been highlighted that the older members of the population are more vulnerable to the effect of COVID-19. The COVID-19 disease has hit older people harder than the younger people. It is because of the reason that the older people are having the comorbid conditions like cardiovascular diseases, diabetes, respiratory illnesses, etc., which will be aggravated by the COVID-19 virus. And this caution has created or has become a scarlet sea. And it led to the discrimination of aged people in the workplace. In many places, the aged people are denied of work. According to the World Health Organization data, more than 95% of the COVID-19 deaths are among people over 60 years. And more than half of all deaths occurred in people of 80 years plus. It created a sense that the aged people are more vulnerable to the COVID-19. And it has a lot of impact on the human rights of the aged people. As a countermeasure, the state is adopting a system of reverse quarantine, restricting the aged people within their houses. And this reverse quarantine adversely affect the earning capacity of the aged people. And when the earning of an aged people are denied, what measures we have taken for their welfare? Do we have an efficient social security system to make them live? Do we have a security insurance? Under the present situation, 60 is not an age for retirement, though it is technically a retirement age. Because of the enhancement of the healthcare standards, the people can work well beyond the age of 60. They can earn their livelihood. But this concept of reverse quarantine severely restrict the earning capacity of these people. Many of these people are unduly discriminated or denied work because of age only. So this violate the right of aged people to earn their livelihood, right to work, right to earn livelihood, right to have an adequate standard of living. It's not only a question of earning. What about the mental pressure which these people are experiencing when they are confined in the house? Whether the counseling system are effective? Even though the counseling systems are effective, how can you mitigate the pressure of loss of income? Thereby, you will be pushing these people to other type of diseases due to stress, thereby violating the right to health, right to adequate standard of living, etc. Even it may threaten the right to life. Again, as regard to the aged people require more medical attention. Because of the pandemic, in many situations, the medical attention is denied to the aged people due to the lack of availability or due to the fear of being contracted the COVID-19 virus. The uncontrolled increase in the number of patients make deficiency in the availability of the healthcare facilities. This deficiency affects the aged people more than the younger generations, thereby violating their rights. Then again, as I have told you, the aged people are discriminated in the access to healthcare system also. As I have pointed out earlier, if two persons are coming to a hospital where only one ventilator is there, one person aged 90 and other person aged 20, naturally, The hospital has to make a choice as to who is to be given this facility. How will make the choice? One of the accepted principle is the principle of utility. When you are exercising this discretion, which will have a more utility, giving or saving the life of an younger person will be more beneficial to the society, or denying it to a younger person and giving it to a person having 90 years of age is more useful to the society. Many times it will go in favor of the younger generations, as they have a lot of time to live, rather than a person having at the age group of 90, 95 or 80 or 85. So it will be unprecedented pandemic of COVID affect the right of such people in an adverse manner. Then its impact on women. Many of the studies show that every pandemic is having a gendered impact. Human Rights Watch in its report say that the Ebola virus outbreak and the outbreak of Zika virus in Brazil had harmfully impacted the women and the girls. The press reports also suggest that the domestic violence during the lockdown has increased significantly. These are all the factors which are affecting the human rights of women. There are several reasons for the increase of domestic violence. It may be due to an increased stress, difficult living conditions. Further, because of the fear of the pandemic, because of the lockdown, because of the social distancing, there is a lack of social support. Man being a social animal, many of our tensions, many of our stresses are ameliorated through the social interactions. The onslaught of COVID has severely restricted the social relations of the people, thereby increasing the social stress. It affects your individual relations also in an adverse manner. That may be one of the reasons why the domestic violence is increasing. Not only that, even the means of escape from this domestic violence has been limited by the travel restrictions and other measures adopted by the state for combating the corona impact. Again, you will see that an International Labour Organization report suggests that nearly 70% of the health and social service providers are women. Means that these people are having more chance of affecting the COVID rather than men. Only 30% of the workforce are men who are working in the health and the social service. Remaining 70% are women. In many places, they are discriminated because of the fear in the community that they will be or they are exposed to the pandemic. It results in creation of creation of a stigma, and a number of discriminatory practices developed in the against the women healthcare workers. Again, you will see that because of the lockdown, etc., schools are shut down, hospitals having no access, thereby most of the care is to be done in home. Children's education, the care of elders, and most often it is the responsibility of the woman to do all these domestic responsibilities. It increases the burden to an unfairly large scale. So thereby, the COVID is having an impact on the women's right. Then another group of people who are affected is the migrants. Though the migrants are a group of people who contribute significantly for the development of a state, their rights are seldom respected. As regard to the right to health, often these migrants experience profound challenges in their physical and mental health and the social stability. Migrants are the most disadvantaged and vulnerable identities in the world. The legal regulation of migration is generally understood from the angle of national interest and security. And these rules often conflict with the rights of migrants. There is a tension between the reluctance of the state to advance the protection of human rights to migrants and the increasing need to articulate and enforce the comprehensive framework of protection. If you are searching in any of the international covenants, you will see that there is no articulate right of health for the migrants anywhere. Even the word migrant is not precisely defined in any of the conventions or covenants. So it creates an insecurity for these migrants even in the international field. And most of the state discriminate the migrants in access of healthcare facilities. This is the case with the regular form of migration. If a person is going to another country with the permission. Along with this regular migration, we will see that there are a lot of irregular migrations also. An uncountable number of illegal migrations are there. They never come to the picture. And they are fearing to come to the picture because of the punishment which will be imposed by the state if they are found as illegal migrants. Often these people are denied without having the health care. And many times if they are found, they are expelled from the country. Even there are cases where the seriously ill migrants are expelled from the country for the reason that they are not the or they are not having the valid documents with them. As far as the migrants are concerned, their right to health is humanitarian even today rather than the human right. Humanitarian in the sense that it's based on the principles of humanity and philanthropy. It's a charity. We cannot find an articulate right to health for the migrant. So the COVID-19 makes their position more vulnerable. That is what we have seen when a number of people fled from the foreign countries to India, particularly to Kerala. The healthcare, access to healthcare in most of the countries are discriminatory and favoring the nationals. This is the impact of COVID on the realization of humanity. And another part of my discussion is the impact of countermeasures adopted by the state for the prevention of COVID. The response in India, if you are looking, you will see that immediately when the COVID-19 started, Maharashtra and Delhi invoked the provisions of the Epidemic Diseases 97 and imposed prohibitions. Subsequently, the lockdown was declared by the central government under the National Disaster Management Act 2005. However, the question is whether these measures are justified under Article 4 of the Covenant on the Civil and Political Rights. Under Article 4 of the International Covenant on Civil and Political Rights, it permits derogation of human rights in type of a public emergency. Can we say that COVID is a public emergency? A public emergency which threatens the life of nation and the existence of which is officially proclaimed. However, it must be to the extent strictly required by the exigencies of situation and consistent with their international obligations. So therefore, derogation from the right under the International Covenant on Civil and Political Rights is permitted only in a circumstance when there is a public emergency which is threatening the life of nation. And there must be a declaration to that effect. Whether it happened in India, it's doubt. And it can be denied only if it is strictly required by the exigencies of the situation. So if the situation requires the denial of it, then it can be. And the article also exempts certain rights like right to life, which cannot be denied by the state even in any circumstance. In India, the measures which are imposed by the state, which are violating or which are having a derogatory effect from the fundamental right, is governed by the principles laid down by the Supreme Court in Puttaswamy versus Union of India. Going by the guidelines in this case, we say that if the state is adopting a measure derogating the human rights, there must be a rational connection between the measures adopted and the object achieved. When you are imposing a strict lockdown, the question is that what is the object for the lockdown and whether this lockdown will be capable of achieving that object. If there is no such a connection, it cannot be justified. And it must not infringe right to the extent greater than is necessary. So restriction can be imposed to the extent of necessity. If a lesser restriction is necessary, only that lesser restriction can be imposed. Then it also says that when you are making the rules for restricting the human rights, there must be safeguard for preventing the abuse of such power. So the question is that whether these guidelines are followed when the government took the measures for the prevention of the ongoing pandemic. And one of the main questions which comes to my mind regarding this COVID is the right to privacy. Why I am asking this, why I am taking this topic is because whether a COVID positive patient is having a right to privacy to the extent that his name and details should not be published. A writ petition has been filed before the Mumbai High Court. I think still it is pending without a decision. Whether I have a right to get the information about a COVID patient. Can the government deny the information of COVID patient to me? I am claiming this right as a part of my freedom of speech and expression, which includes my right to collect the information, my right to get the information. Of course, the right to privacy has been recognized by the Supreme Court as a fundamental right under Article 21 in Rajagopal versus State of Tamil Nadu. However, is it an absolute right? According to Supreme Court, it is not an absolute right. In Mr. X versus Hospital Z, the Supreme Court said that if the information is necessary for the prevention of crime or the prevention of disorder or for the protection of health and or morals, the information regarding the disease can be disclosed. So this right is to be analyzed in the light of the decision of the Supreme Court in Mr. X versus Hospital Z. If I have a right to protect myself from a COVID positive patient, can that information be denied from me on the ground that the other person is having a right to privacy? And it is more grave when it is affecting the right of the people as a whole. Whether this ICMR guidelines prohibiting the disclosure of information is having the force of law. They have issued the guidelines on the ground of an apprehension of stigmatization. They assume that COVID-19 is having a stigma, and therefore the information cannot be disseminated. Of course, there may be instances of discrimination, there may be instances of stigma, but whether is it a proper way to ameliorate that stigma or prevent the stigma? Of course, it is sensitive information and it is to be declared very carefully, no doubt about that. But subject to certain safeguards, such information is to be disseminated. That is part of my right to know. Then the freedom of speech and expression. That is the right which was in collision with the right to privacy. Then another right is the freedom of movement. The recent rules of lockdown. The principles of quarantine seriously affect the freedom of movement of the people. The freedom of movement of people guarantees the freedom of every person to move around the country within its boundaries. Even it extends beyond the boundaries, according to the Supreme Court in Maneka Gandhi versus Union of India, where Article 21 was interpreted, and the Supreme Court said that a person is having a right to travel abroad. So this lockdown and suspension of the transportation systems seriously affect the freedom of movement. But it is justified on the ground of public health. But these type of restrictions are absolutely necessary or not? That is the question. And another right which is affected is the freedom of assembly. The social distancing norms and other norms prevent the people from gathering for more than a definite number. Then the right to equality, the most precious right of a human being. In every time of pandemic, the people are often discriminated and people are treated with stigma. There are many cases. The Human Rights Watch reports that the people affected with HIV had been discriminated in Kenya, South Africa, Philippines, US, even in India. We know that the people were fearing to interact with people who are HIV positive. They were discriminated. A kind of stigma was attached to the disease. So they were having great difficulty in getting the health care, getting the job, attending the school, attending other public places. COVID-19 is no exception. The recent reports show that the plight of people who are affected with COVID-19 and the people who have recovered from the COVID-19 is not satisfactory. Even the people who are coming from distant places like other states and abroad were discriminated and a kind of stigma was attached to them, violating the principles of equality under the Human Rights Conventions and the Constitution. And another right which I would like to discuss is right to autonomy. Right to autonomy means it is my privilege, my right to decide what is to be done with my body. Can you impose any restrictions on my body? Can you ask me to wear a shirt which I don't like? Can you insist for taking an injection which I don't want? Can you insist for taking a food which I don't want? These are all the things which I have to decide. I am competent to decide on what I should do on my own. The main thing which affects this autonomy is the compulsion to wear the mask. You might have seen that in America there were large agitations. I don't want to wear the mask. How can you compel me to wear the mask? It was compelled on the ground that it is necessary for the public good. Whether I should sacrifice my right for the public good? If so, to what extent? Autonomy gives me a choice as to what is best for me. Then, last but not the least, the right against torture or to cruel, inhuman, or degrading treatment or punishment. So the International Covenant on Civil and Political Rights under Article 7 prohibits torture, then cruel, inhuman, or degrading treatment or punishment. Any type of cruel, inhuman, or degrading treatment is prohibited under Article 7 of the International Covenant on Civil and Political Rights. When a person is critically ill, if you are denying him the treatment, does it not amount to cruel, inhuman, or degrading treatment or degrading treatment? Is it not the violation of this article? Whether a state is not bound to give treatment to such people? We have seen the people dying in roads, people dying in vehicles. Hospitals are denying the treatment. These all type of activities violate Article 7 of the International Covenant on the Civil and Political Rights. It is for the state to take measures. This obligation is mandatory for the state to take measures for preventing such activities, for the protection of people against such a cruel, inhuman, or degrading treatment as per the mandate of Article 7 of the International Covenant on Civil and Political Rights. So let us conclude. It is a situation which is unprecedented. Pandemic created a lot of dilemmas. It is a huge challenge to the realization of human rights. So here the state should have a proactive role. A proper balancing of exigencies with the protection of human rights is necessary. Here we have to balance the interest of society and the interest of the person. One of the important things which I forgot to mention was the right to education. Schools are shut. Access to education is limited. Though many are giving the online mode of education, Education is not just imparting of information. The education, according to the Human Rights Universal Declaration as well as International Covenant on Economic, Social, and Cultural Rights, is it is for the full realization of the human personality. Do these online modes are capable of developing the human personality? Education as a means of developing human personality requires an interactive process between a mentor and a mentee. Most of this education is acquired by the students by interaction. The COVID-19 pandemic has severely restricted this process of learning. What is going on is only teaching, not learning. And where we are disseminating the information. So even these rights and this education is very important. One as the human right and other as a means of realizing the human rights. Person who is having the knowledge of human rights can only accomplish human rights. Therefore, the knowledge and education are integral part of a meaningful realization of human rights. Even this does not happen during the time of this pandemic. So these are my simple thoughts on human rights during a pandemic era. It is only the random thoughts. It is not complete. I am leaving this topic for a further discussion and further research of the participant friends. Thank you.
Thank you, sir. Your speech was interesting and thought-provoking. Your words have inculcated in us unexplainable enthusiasm to strive hard not only to free ourselves from the clutches of the pandemic we are in, but also for a near and dear future we are going to be in. Sir, there are a couple of questions in the chat box. Shall I read it, sir? Sir?
Yes.
The first question is from Mr. Videsh. The question is, why freedom of speech is selective in India? Can you please define what is the actual meaning of freedom of speech as per Constitution? Why is freedom of speech selective in India, sir?
Freedom of speech is selective
In India. Why freedom of speech is selective in India?
there is no such a definition of freedom of speech under the Constitution. The freedom of speech is available under Article 19 to all citizens. But the freedom of speech is not an absolute right. There are certain grounds on which the freedom of speech and expression can be restricted. So most of the rights under the Constitution are not the rights which are unrestricted. The reasonable restrictions can be imposed on the freedom of speech and expression. And the grounds for such restrictions are specifically provided under the Constitution itself. So we cannot say that this right is a selective right. Rather, where it is in necessary circumstances, it can be restricted. For example, if my speech is defamatory to a person, can we permit it? We cannot permit it because it will affect the right of another person, isn't it? So therefore, the restrictions are there. Then, if it is against the morality, can we allow such a speech? On the ground of morality, it will be. If it is against the national interest, if it is against the public order, so certain restrictions are imposed on the freedom of speech on the grounds which are specified under the constitution itself. But I don't subscribe the view that it is a selective.
Another question from Mr. Videsh. Has China not violated human rights of whole world by spreading corona? Is there any action from UN?
The first of all, the thing is that we cannot comment on any imaginary reports when we don't have a clear evidence as to the origin of the virus. So there are diverging opinions about the origin of the virus. And some people allege that it is created in the laboratory of China. But without having the sufficient evidence of its origin, how can we accuse a country, or how can we malign the reputation of a country, or how can the UN or anybody take action against such a country? Do we have any evidence that it is created in the labs in China? I don't think so. There is diverging opinion about that. So better we shall not enter into such a fields where we don't have concrete evidence or concrete information.
Another question from Basanta. UN warns coronavirus pandemic is becoming human rights crisis. How?
That is what I think I explained throughout my lecture, isn't it? The pandemic virus has affected every field of life. It has affected the right to life. It has affected the right to health. It has affected your right to work. It has affected the freedom of movement, freedom of assembly, the right to education. What is the field which is left by the impact of the COVID-19? Even the countermeasures which are taken by the state, which may be necessary, are yet to assess whether they were absolutely necessary or not. But for the time being, assume that it was necessary. Do you think that they are in consonance with the human rights? So, in case of realization of human rights, as well as in case of the measures for prevention of human rights, if we are analyzing, we'll find or we will feel that there is a large amount of human rights violations. But my statement is subject to further research because it's a new area. A lot of research is necessary in that area. But I feel that we have to find out whether these measures were necessarily to be imposed on the people. For example, we know that in the initial stages of the pandemic, the government prescribed a quarantine of 28 days for the people. Subsequently, it was reduced to 14 days. Now it is 7 days. So see, from 28 it is 14, now it is 7. what kind of a restriction is necessary, whether it is 7 days apt, 14 days apt, or 28 days apt. So this issue is to be resolved by a proper research, and the government should come with the proper information for the people. So somewhere there is a lacuna in the dissemination of information in case of this COVID. That is what I feel.
So another question from Mrs. Sharmishka Banik. During the COVID-19 situation in many places, healthcare services were not adequate. Then how will right to health and healthcare services associate with one another?
That's what I told. I was saying the right to health and the right to health care. There is a difference between the right to health and the right to health care. If I want to give a right to health, a mere declaration, by a mere declaration, I can ensure that you have a right to health. And if it is violated by somebody, the state will be forced to take action, and you can approach the court. Whereas right to health care demands a positive action from the state. The state has to establish proper infrastructure for making the health care available. So there a positive action from the state is necessary. So in a COVID situation, we don't say that there is no right to health, but the right to health care is severely restricted, or in many cases it is denied. That is happening in this situation according to my perception of the things.
So another question from Mr. Dheeraj. How effective is NHRC in India, especially in matters of prevention of atrocities on Dalits and other marginalized groups?
Pardon?
How effective is NHRC in India, especially in matters of prevention of atrocities on Dalits and other marginalized groups?
See, when you are looking at the NHRC, when you are analyzing the functioning of NHRC, you will find that NHRC most often is a dog which can bark but cannot bite. The power of action of NHRC is very limited. In certain cases, it can recommend for payment of some interim compensation. But if the NHRC finds that there is a serious violation of human rights, the recourse which can be taken by the NHRC is to approach the appropriate court for the realization of that human right. So when we are discussing about any kind of human right, or any human right of any group of people, the efficiency of the National Commission is a question. So with this power, I feel that the National Commission may not be able to protect the human rights in a meaningful manner. The Protection of Human Rights Act needs to be amended for giving more power to the National Human Rights Commission, and the State Human Rights Commission. So this is the case with many of these commissions. Many of these commissions are having only the power to make recommendations. When it comes to actual implementation or the enforcement, its functioning is not very satisfactory, or its powers are not very satisfactory. Either it is the case of a scheduled caste or it is the case of any marginalized group. I think this is the
So one more question from Mr. Dheeraj. Are all human rights incorporated in the Constitution? If so, why the political power denounces human rights in India? Sir?
Sir,
Sir, it's not audible.
sir, okay, Radha, vote of thanks like vote of thanks like ഞാൻ ഒന്ന് വിളിച്ചു നോക്കട്ടെ സാറിന്.
Sir? Sir? Mira?
ഒരു മിനിറ്റ് ഞാൻ ഒന്ന് ചോദിക്കട്ടെ സാറിൻ്റെ അടുത്ത് കൺക്ലൂഡ് ചെയ്യട്ടെ. Radha,
Yes?
please wait for 1 minute. Sir will be back.
Okay. Okay.
hello.
Yes, sir. Yes, sir.
Now audible.
Yes, sir.
Yes, sir.
Yes.
Okay. Please repeat the question.
Yes, yes.
Madam?
Are all human rights incorporated in Constitution? If so, why the political power denounces human rights in India?
If you are going through the rights which are enumerated under various conventions, already I have told you that there are two types of human rights. One type of human right is the civil and political rights. And other type of human right is the economic, social, and the cultural right. The civil and political rights more or less comes under the fundamental right part of the Constitution of India. And the civil and political right, sorry, the economic, social and cultural right, some of these rights have been incorporated under the directive principles of the state policy. Under the mandate of International Bill of Human Rights also, the civil and political rights, it is mandatory for the state to implement. And the economic, social and cultural rights, the state has to implement when the state is having the capacity to implement. That's what I told you, told that there is a concept of a progressive realization. And whenever the state is capable, this civil and economic, social and cultural right also should be made justiciable. And in India, these non-justiciable rights, some of them are found in the directive principles of the state policy. And by the interpretation of the Constitution, particularly the Article 21, many other rights are also now read into the Constitution of India, and it is enforced by the court in India, like right to health, right to environment. Such rights are not articulated as fundamental right, but now it has been read into the Constitution by the activism of the Supreme Court of India. And therefore, these rights can be enforced or implemented. And other rights which are enumerated in the Universal Declaration or the International Covenant are not considered as human rights according to the Protection of Human Rights Act. But many times, these rights are also read into the Constitution by the Supreme Court. For example, Article 9 of the International Covenant on the Civil and Political Rights. Article 9 of the International Covenant on Civil and Political Rights provide a right to compensation if a person is, or if a person's right to liberty is arbitrarily deprived of. However, when the International Covenant on the Civil and Political Right was ratified by India, India ratified the covenant with a reservation that Article 9 is not applicable in India. But the Supreme Court of India in Nilavati Behra versus State of Orissa took the help of Article 9 of the International Covenant on Civil and Political Right and awarded compensation by creating a particular category of remedy. They termed it as a constitutional tort, which is arising from the violation of a fundamental right. So many of these rights are read into the Constitution by the Supreme Court. But still we cannot say that all the rights which are enumerated in different conventions, covenants are incorporated in India. Still there are certain rights, the right to asylum. The right to asylum is a human right under the International Covenant on the Civil and Political Right. But this right to asylum is not recognized as a right in any of the countries under the national law. Still it remains a human right in the international level, not transformed into a right in the national level. So therefore, we cannot say that all are now incorporated, but slowly the law will progress and these rights will be incorporated to the Constitution or the domestic law. And regarding the implementation of this right by the political authorities, these rights are mostly implemented by the political authorities or the government. But there are instances where it is violated. That's why it became necessary for the constitution makers to provide remedies for violation. If no question of violation, no question of remedies. Article 32 of the Constitution or under Article 226 of the Constitution, a person whose right is violated, they can approach the court. Under Article 226, you can approach the High Court, and under Article 32, you can approach the Supreme Court if the fundamental rights are violated. And the decisions of the Supreme Court are more often implemented than violated. That is the experience. There may be instances where it is not complied with, but ultimately, if a person is pursuing, the government will be forced to implement the decisions of the Supreme Court.
So last question from Mr. Kumaravel Raja. If the COVID patient refuses to give any information, whether it becomes an offense, how can they use the right to privacy as a defense?
What type of information? Now the matters regarding the COVID-19 has been brought under the National Disaster Management Act. And it is a debatable question. Do I have put the right to privacy as a right? Again, I am referring to the decision of the Supreme Court in Mr. X versus Hospital Z. The Supreme Court came out with the conclusion that the right to privacy is not an absolute right. If certain informations are to be disclosed, then the authorities can disclose that information. It means that the authorities can extract that information from the concerned person also, if we are going by the rationale of the decision in Mr. X versus Hospital Z, because it is a matter which is affecting the public health. So the larger consideration is the interest of the society. So many times the individual will have to sacrifice his right for the interest of the society. So therefore, violating a rule under the Disaster Management Act by not disclosing certain information, it is doubtful whether that person can get the defense of the right to privacy as the law exists now. But the law is not absolute. Many times the law is depending on the individual philosophies of the persons who are interpreting it. So as of now, as the law stands now, I don't think the right to privacy is a defense when if a person is compelled to give an information which is necessary for the preservation of the public health.
So thank you, sir. Once again, we thank you for your crystal clear speech about.
That I have one question, sir.
Yes. Yeah.
Yes.
Sir, thank you for so much for your elaborative talk on human rights in pandemic era. My question is a general question. We do hear from the news that many private ventures are reducing the salaries of their employees, citing the reason of the COVID-19 pandemic. Whether our legal system has any remedy for such acts?
It's a very difficult question to answer. So when you are compelling a person to pay, the question is that from where he has to pay, isn't it? So the pandemic has affected. Already there are directions or requests from the government that the salary shall not be reduced. But now the question comes, it is not a legal question actually. It's a question. The question is that suppose I have to pay, from where I have to pay? I am not able to run my business. I am not able to get any income from my business. No person is coming. No demand for the goods. So can we compel a person to run a business or run an enterprise with the money from his pocket? Will this be a sustainable one? That is the problem. Whether it will be a sustainable one. I may be able to manage it for 1 or 2 months. But when we are looking at a long term, that's what happened in the case which I referred in case of Gujarat regulation. So in Gujarat there were a shortage of workers, and the income of the industry reduced. So the government found a via media, thereby the government made a declaration that the employer can ask the employee to work overtime. If normal period is 6 hours, they made the rule that it can be extended up to 12 hours. Even there was a prohibition for the employment of women and children in the night. That prohibition was also taken away, so that the industry can run. And the regulation provided that for the overtime, they need not pay the overtime wages. Normally, the overtime wages are double the wages of the regular employment. So the regulation provided that for the overtime also, the employer has to pay only at the rate of the normal wages. But when this matter came to the Supreme Court observed that the burden of the financial loss cannot be put on the worker, isn't it? The same logic will be applicable to the employer also, isn't it? So there should be a balancing of the interest of the employer and the interest of the employee. The employer should be able to continue with his industry, and he should be able to sustain his industry. So otherwise what will happen? The only recourse for the employer is to shut down the industry. Isn't it? So when we are making a labor legislation, we should balance the right of the employer and the right of the employee. That is my view on that question. I don't know whether it is right or wrong, but from the overall picture, this is my view of the situation.
Okay, thank you, sir. Thank you very much. Janita,
No, nothing else. The observation is it was very useful and informative session, sir. We are so much grateful towards you on behalf of our IQSC, IIC and HRDC Kannur, sir. Yes, we are happy that we were together in this pleasant evening to listen to you about all the, you have given a clear vision about everything. Thank you so much, sir. Thank you.
Thank you.
Radha, is Radha?
Pass on to the final session.
Shall we proceed to the vote of thanks?
Yeah, yes.
I'd like to invite Mrs. Jackie, Assistant Professor of Botany, to propose the vote of thanks. Jackie, are you there?
Am I audible?
Yes, ma'am. Yes.
A very good evening to all. I deem it a great honor and privilege to propose the vote of thanks on this auspicious occasion. Let me first of all start by giving glory to the Almighty God for making today's occasion a resounding success. First and foremost, I thank your resource person, Dr. Girish Keshavapilla, Principal Bhavan Senne Palkibala Academic for Advanced Legal Studies and Research Kozhikode, for his enriching, interesting and informative talk on the topic Human Rights in the Pandemic Era. He enlightened us with his words, which prompt us to act and be aware of the protection of human rights during pandemic situations. On behalf of IIC and IQAC of Sree Ayyappa College and HRDC Kannur University, I thank you, sir. My heartfelt thanks to Dr. A.M. Sridharan, Director, UGC HRDC, Kannur University, Kerala, for his valuable guidance and support. We are grateful to our Madam Principal, who is the backbone of our institution, for his unstinted support and encouragement. I also express my gratitude to organizing secretaries of this short-term course. Am I audible?
Yes, yes.
Yes.
I'm also expressing my gratitude to organizing secretaries of this short-term course, Dr. Meera, Dr. Janada Kumari and Dr. T. Anita, who have worked hard to make this program a memorable success. I would like to thank Dr. Meena, IQAC Coordinator, Dr. Smita Nair, President IIC, Dr. Suma Devi, Convener IIC, and all other coordinators and members of IIC for their support. Last but not least, I thank you all.
Radha, moderate it and complete it, Radha. Maybe she is.
Thank you, Rafi. Okay, thank you, Rafi. Before the end of the session, I would like to remind you about the feedback once again. Your insights will help us to shape future events like this. And dear participants, join us tomorrow at 5 p.m. for the 5th day of the short-term course. We have for tomorrow's session a very eminent resource person, Dr. M. Sriniwas, Professor of Law, University College of Law, Telangana, who is going to enlighten us on the topic human rights on women. And so we'll meet tomorrow at 5 p.m. Thank you for joining us today and hope you all have a wonderful day.
Thank you, sir.
Thank you.
Thank you, sir. Thank you.